entered between JBAC, so the name has been JAC like that. Even that also that they treated as third party information, even that is also not provided. And we heard that should also be given. CAC.
Because your orders create problems for other states.
Though they are not Supreme Court, for example, as held by the Information Commission New Delhi, this is their pleading. Bangalore Metro Rail Corporation. One application was filed asking their board resolution. Second is agreement entered between the JBAC, now the JACA, and Metro Corporation. That state government has invested so much, central government has invested so much. A part has been given by JBAC as loan. Even giving that information, board resolution, they are citing your decision. Central Information Commission and CAC 2006-8 to 2007 request for copies of board meetings and agenda. Appellant had requested by the
Sir, it can be asked is that especially Central Information Commission also.
No, the thing is that I would like to ask the Honorable Commissioner is that are you giving your decision by taking the Central Information Commission's point of view?
No, we are not giving decision like that.
So you have to state very clearly.
Thing is, they are stating the decision of Central Information Commission.
So
and even they have said that this, what is that, company board, companies act also. That also we have overruled and we have directed to provide this information. There has been challenge and the High Court has stayed our question. But because there are contradictory views, it is easy to the High Court gives us stay.
One thing we have to remember is that CAC is not the apex body. Commissioners are just not bound by what
No, they are not. We are not. They are citing the example.
Let them say. See, there are a number of cases.
No, you give your own interpretation. It's not necessary. You give your own judgment.
1 minute. The CAC has said so. Therefore, you give the decision accordingly. The moment we say, if you want to get the decision from CAC, you go to CAC. Don't come here. So you have to be a little firm about this. Independence says we have nothing to do with that.
Agreement with JBAC. It's an international body.
Yeah.
They said that it will affect the company position.
I think we should discuss this during the debate. It's not a mainstream discussion.
Okay. We'll discuss. I have a similar problem. We'll discuss separately.
Issue of access to minutes of board has to proactively disclose a statement of the boards, councils, committees, and other bodies consisting of 2 or more persons constituted as part of it, as its part for the purpose of its advice. And then they have to say whether meetings of these boards, councils are open and whether minutes of such meetings are accessible to people. So I'm not expressing an opinion, it's a question here, it would be nice to get an answer. Supposing, let us say, a public authority takes the position that minutes of a certain board that it has constituted or it is part of or whatever are not going to be accessible to people. They take a decision. Now, should that decision, which makes it a class exemption, should that not be linked to Section 8? And will it survive as a class exemption in every case?
May I respond? Invariably, people ask for the board agenda papers and the minutes. And invariably, the banks have been refusing not to give it. And invariably, I have been allowing the disclosure of the board agenda and board minutes. They also argued, just like you said, they said that no, we have decided that this cannot be disclosed. I said that is contrary to the provisions of the law. You can't, only if any of the part of the board agenda or board minute is covered separately by the 8.1, any provision, only then that portion you just, say in your order that this portion we are withholding, for the following reason. But the rest you have to disclose. In fact, I have just written to Reserve Bank of India that instead of people going to them every now and then within 3 months, they should disclose publicize their disclosure policy with regard to their own board agenda, and after every board meeting they should put it in their website, the board agenda and its decision, except those which they think is not in the interest of India and take 8.1A, mostly they take 8.1A as their,
So I suppose that should count as best practice.
JBIC, which is a part of the Water Authority or the Irrigation Department for the state government, they are compelled to declare the policy matters in their website. We have issued instructions in Kerala regarding.
Films is a constitutional bench decision, purely private body, public function. You come under the authority of the, you become a public body in a sense, and you come under the constitution. The second is Anada Mukta Sadguru.
So, with respect to RTI, have they said it's a public authority?
See, no. But I'm saying, I'm looking at the wording. It's a very ambiguous kind of wording, because here it says established or constituted by or under the Constitution. So it's a very odd thing. But they have said that a private body will come under the Constitution, because it will be taken like a public body, like any public body.
Everything comes under.
Now see, suppose in Z Telefilms they said that if it's a private body doing a public function, they will come under all the control of the Constitution which public bodies come under.
So which means they will have to follow reservation principle in employment.
No,
They will
no.
have to be subjected to
No.
CAC control for vigilance.
No.
So how are
They are subjected to the clauses of the Constitution, namely discrimination. In the organization, if there's in a purely private body, let's say a private restaurant, right? I don't employ women. You can't touch me. You can't file a case in the High Court against me saying that they're not employing women. But if in you're like Z Telefilms, like that big company, they'll say I'm a private body. They say you come under the Constitution. You can't discriminate. So certain provisions of the Constitution grab you.
That's a state as per the.
That's not state, but it's like an agency or instrumentality of the agency of the state.
I think the order will have to be read to understand.
Yeah, read a little. What I am saying is, because I have a feeling you might be able to use the second one, which is repeated in Z Telefilms, is Anada Mukta Sadguru case, where the Supreme Court said private institutions, all private institutions, whether they are funded or not, come under the Constitution again, because it's a public function.
Everything comes under the Constitution.
No. All, say for example, race course, a private race course doesn't come under the Constitution. Private restaurants don't come under the Constitution.
They do. They have to follow the statutes of the country.
No, that's
because they are under the
different.
Constitution. See,
No.
Nothing in India.
No. See, the Constitution is enforceable only against the public body. Right? Now that law has, public body generally meant government funded. But now that law has changed in India and in the UK to private, no funding, but you are performing a function which was once upon a time governmental. Right, yes. So that's what she meant, electric companies.
So which means the reservation is a constitutional. It's a constitutional.
No, correct. But government establishments, reservation is not in private sector.
But why? Once the Supreme Court declares a
For reservation is reservation only for public bodies. Now, if they amend that article,
the G Telefilm is also a constitutional. Constitutional.
It will come under the constitutional enforcements. It will come under. I'm saying this is the broad thrust that certain private bodies.
If are not taken up, when decisions are arrived at by information commissions, I will not mention the case here. But probably it will come out. Anadi Mukta Sadguru is one case that I have read. Z Telefilms I have not seen. There they have expanded, or rather they have clarified that a writ, the power of the High Court, can lie against a body that performs public duties irrespective of the fact that it might be in the private sector. That was the argument that we posited in a case MLCs and other elected representatives are public authorities or not. We quoted Anadi Mukta Sadguru, but sadly that decision which came out later on did not take into account this argument at all. Because very clearly, by the definition of the term authority given in Anadi Mukta Sadguru, every MP and MLA has to be treated as a public authority under the RTI Act.
To move any further, so I think we've actually run out of time, but Colin has allowed us to take 10-15 minutes from his session. So we have one or two matters quickly to go over. I just want to, as a matter of historical interest, because Mishra Saab showed some interest, tell you that 2F was put as an alternative to the South African regime. In South Africa, the RTI Act covers all private bodies. So all shops and this and that. And when we spoke to our friends in South Africa, they said it's a nightmare. It doesn't work because we've got 250,000 hamburger carts who are all public authorities. So this was put as an alternative. We were probably wrongly informed, but I remember very clearly that the lawyers there informed us that if you use the terminology body, it means only a corporate or a register, etc., etc. But if that is wrong, then obviously we'll have to, something will have to be done. Now the next issue that we flagged out here, and which I think we could probably deal very quickly with, is denial because files go missing. And I think this is something where there are laid down procedures. Now what I understand, I'll quickly put it across to you, is that you have two options if a file goes missing. You can order, and you can do both. You can order that the file be recreated insofar as that is possible, because I believe that happens in the government. And or you can order an FIR to be filed against it. We've had an experience, in fact, with the CIC where the Ministry of Environment and Forest claimed that 3 Godrej Almiras full of files of the Maheshwar project had gone missing from their office. So an FIR was filed on the orders of the CIC, but there was no action, because who takes action on FIR? Till we filed an RTI with the police, saying what action has been taken on the FIR. And you won't believe it that within a week of that, all 3 Almiras were found. Information commissioners or commissions, is it adequate if they feel that, look, the PIO is telling the truth that the files are no longer traceable? Is it adequate then to say, well, then the case is closed, or should something more be done? I would request Mishra Saab to start on this, because having been Secretary DOPT, I'm sure you know all the rules.
I think their files are not available. I think this is not acceptable. I mean, one single file, it is possible that when you have thousands of files, one single file may be missing, in which case he can be asked to search for it again and again, and if it fails to find out to confirm in a sworn affidavit that it is not traceable. But if the issue is very important, the exercising the powers, the public authority can be directed to institute some kind of an inquiry, a disciplinary proceeding, fix responsibility on individuals, or in the extreme case, file an FIR.
In this case, we ask the PIO to file affidavit that the file is missing. Then we ask the Constitutional Inquiry Committee of 3-4 members, senior officers. Then later on it was traced out. That is one case. Then recently another case said that documents are missing. I said, you see, it should be in public domain. How can document can be missing like this? Otherwise, your public authority, who is head of department, will be responsible for this. Then again, I suggested either you file FIR, or if you don't file FIR, then I will constitute an inquiry. Then responsibility to fix that person, how it happened. So if you don't fix responsibility, how file is missing, then head of department has to be responsible for this. So like that. Then second one, they have filed FIR. But after filing FIR, I will follow it. I don't know. Again, it is a police whether they'll take action or not. So that's I do not know. That is another case. Then another again documents not filed. That was about mark sheets, mark statement of Public Service Commission. So there also I put inquiry committee. Then inquiry reports, they have not fixed any responsibility. They said this thing, that thing, so many things. Then there I have order, using that section 18, that 8, that the record management and all. I think that is the responsibility of the public authority, how they should maintain. So such cases are there. I think